Good evening, everyone. My name is Sharifa, and thank you so much for joining us this evening for BicTok 15. One second. For BicTok 15, Enforcing and Challenging Performance Bonds, Contemporary Developments. I see that my colleague has posted a PSA in the group chat, so I'll just highlight that. Please ensure that your account or Zoom name handle resembles your actual name to cross-check against the registration form if you're looking to collect your CPD points. So if you are logged in as Sharifa Appellant or Sharifa Claimant, please change it to Sharifa and make sure that the account that you're using to log in is the same email that is used in your registration form. Now, let's move on to the main agenda of the day. I'd like to introduce our panelists. First, we have our moderator, Mr. Shannon Rajan, who is a partner at Screen. Our panelists, Mr. Vishal Kumar from James Montero Advocates and Solicitors, Mr. Chun Hon Leng from Sanjay Mohan Advocates and Solicitors, and Mr. Adrian C., a managing partner at Belden Advocates and Solicitors. Without further, one more thing. If you have any questions throughout the session, please feel free to put it in the chat box, or if you'd like, you can turn on your video and your mic at the end of the session and engage with the panelists during the Q&A session. So without further ado, I'd like to pass the floor to Mr. Shan Rajan to begin.
Thank you, Sharifa, and welcome everyone to BicTok 15. Now, let's dive straight into it. The issue at hand, or the topic at hand, is performance bonds. Maybe a brief introduction about performance bond to set the tone, and then we'll move straight into the webinar, so to speak. Now, performance bond plays a very crucial role in the construction industry. It is there to safeguard the project owners against contractors' failures. Essentially, it's a type of insurance for the project owner. It is a guarantee that the contractor will complete the project as specified in the contract. Now, the bond is issued by a surety company, which acts as a middleman between the contractor and the project owner. So the surety company evaluates the contractor's financial stability and ability to complete the project, and then issues the bond to the project owner. Now, you might be wondering, why is this important? Well, performance bonds are crucial in the construction industry because they protect the project owner from financial losses. Without a bond, the project owner would be at risk of losing money if the contractor doesn't finish the job or doesn't do it in the agreed upon standards. However, there are potential abuses and problems that exist, which necessitates vigilance, clear communication, and due diligence to mitigate the risks. We'll be exploring all these issues and many more with our esteemed panelists today. Now, to keep the webinar a bit punchy, we've agreed to have it in a very fluid manner. It's going to be a fire chat conversation. So I'll be asking certain questions to the panelists, and the panelists will be having a conversation about these things. And let's see where the conversation takes us. So let's dive straight into it. And if I could invite all the panelists to, yes, unmute yourself. Okay. So question one, from an employer's perspective, is there such a thing as a good time to call on the performance bond? Then another issue I would like maybe to put up there to the panelists would be, what are the considerations before calling on the bond? And once a decision is made to call on the bond, what are the preparatory steps that ought to be taken by the employer? Maybe to lead this conversation, could I invite Vishal to handle these questions? Over to you, Vishal.
Thank you, Shannon. Good evening, everyone. On the first question, is there such a thing as a good time to call on the bond? Yes, there absolutely is a good time to call on the bond. So as far as an employer is concerned, we have two types of bonds. We have a conditional or default bond, or we have a unconditional.
Sorry, we are
or,
losing you, Vishal.
Sorry, unconditional bond.
Conditional and unconditional.
Apologies,
And
can you
then,
hear me now?
yes, we can. Go ahead.
Okay. Yeah. So we have a conditional bond, unconditional bond. A conditional bond is a bond where you usually have a clause in the said bank guarantee that says that in the event the contractor is in default of its performance, the employer is entitled to call on the value of the bank guarantee or such sums as stated in the bank guarantee. Hi, sorry, is there an interference?
Not on my side.
Okay, so as far as a conditional bond is concerned, more often than not, there are conditions before an employer can call the bond. Whereas an unconditional bond
Very good.
ordinarily does not have conditions, but it does not mean that the employer is entitled to, is automatically entitled to said bond.
Vishal, maybe
It
I
just
could
provides
sorry, Sharifa. I think there's yeah,
Oh, we have
no,
one
one or part.
participant
Yeah.
under MST. Okay, all right.
Okay. Maybe Vishal, taking this
Yeah.
conversation along, maybe you could identify some of the conditions that you normally see in a conditional bond.
So the usual condition is that the contractor must be in default under the contract. That is something that you'd commonly come across. Whereas for unconditional bonds, you wouldn't have such a clause, but the employer still has to follow the mechanism as set out under the contract. So whilst you have a trouble-free way of calling on the bond, the employer is still bound to comply with the specific terms in the contract. So just to give you an example, last year there was a case in Construction Court 2, Kuala Lumpur Construction Court 2. The name of the case is Eversendai and Samsung UEM joint venture. That contract was a modified FIDIC contract. Unconditional bond was provided by Eversendai to SUJV, Samsung UEM joint venture. But in the FIDIC contract, there was a very elaborate and specific clause which had to be complied with by SUJV before it was entitled to make any claims, including a claim on the performance security or the performance bond. For example, the employer, in this instance, which had to be followed up with substantiation of the amounts being claimed. That then had to go through a consultation process, and SUJV was then to render a fair decision post all these processes. Only upon the issuance of a fair contractor's decision was SUJV entitled to call on the performance security. And even then, there was a clause in the contract that stated that once this decision has been made, the contractor must give the subcontractor an opportunity to make payment. And the bond can only be called 42 days after the contractor's decision. Now, in this case, what happened was, at least High Court found that the main contractor had failed to provide reasonable notice, had failed to go through the consultation process, consequently had failed to issue a fair decision, and to compound the breach, they had called on the bond 1 day after the issuance of the contractor's decision, notwithstanding the contract saying you have to wait 42 days. So in that situation, the court found that notwithstanding it being an unconditional on-demand bond, the main contractor had failed to meet the condition precedents as set out in the contract before such a call could be made. And the court found that in such a situation, the call made by SUJB was unconscionable.
So what you're saying is, though you have a unconditional bond, there could be terms in the construction contract that attaches a very comprehensive procedural mechanism to trigger the bond. Is that right?
Yes.
I see.
It not necessarily has to be a comprehensive clause. I've also come across a case where, for example, when you make a call on the bond, it's an unconditional bond as well, but when you make a call on the bond, in your letter to the bank, you must state that the contractor is in breach of the contract. You don't have to set out why he's in breach. All it says is you must state that he's in breach. And failure to do so can amount to unconscionable conduct.
Okay, maybe I want to try and bring Adrian into the conversation.
Yeah, sure.
What about your experience when dealing with conditional or unconditional bond? Do you see a lot of bonds in the manner in which Vishal has mentioned?
All right. I think going back to the earlier years of my practice, I think the issue of conditional and unconditional bonds were there. Whether a bond is conditional and whether a bond is unconditional, I think that's quite settled, quite a settled position. That depends on the wording of the bond itself. However, I think in recent years, most employers will want the bond to be unconditional, which means that you will have wordings in the bond to say, notwithstanding any protestations by the contractor, once a call is made by the employer, the bond is payable. But that's where I think Vishal was touching on the issue of unconscionability. Going back to the early part of the question, whether there is such a thing of a good time to call on the bond, I think it depends on how you see it from the employer's perspective. To my experience, I think ideally, no employer will want to call on the bond because it will mean that the project is in some sort of trouble. What do I mean by that? Usually you will see that a call will be made either when there is a termination situation or when there are issues of extensive delays where LADs will be added to it, major defective works, which exceeds the money that the employer is retaining. Because let's not forget, in a construction contract, the employer has retention sums. So usually when you need to consider calling on the bond, it will mean that whatever you're holding is not enough to cover for this excess, so to speak, whether it's cost overrun, whether it's on account of back charges, LAD set-offs, or so on and so forth. But when it comes to that, I think I agree with Vishal that you need to know when you call on the bond, and you need to make preparatory steps towards it. What I mean by that is you need to look at your underlying contract to see what are the steps that you need to take to crystallize your claim before you assert the breach and then call on the bond. Because if you have any misstep from the employer's perspective, that will likely lead to an evaluation that the conduct is unconscionable, and then a restraint on the call can be made by the contractor once the call has been made. So I think that's perhaps a little bit of what I would like to add to what Vishal has mentioned, and maybe Hon Ling can chip in.
So I'm going to bring Hon Ling in on the point of, is there such a good thing as a time to call on a bond? And Vishal said, absolutely. Hon Ling, I think you beg to differ.
Well, I mean, I would say there's never a good time to call on the bond, because I do agree that ultimately when the bond is called, means that it's almost like broken beyond repair, whether in terms of the relationship or whether in terms of the project. So I think that's where a lot of the problems happen. And the problem is that no doubt, I think like what Shannon have introduced earlier, the bond right at the beginning is really to give the employer a form of security. But I think we have seen enough to know that, as is often the case, a bond is open to abuse or some oppressive method of using it, whether you want to use the bond because you have a hole to fill in, okay, just to get the money before the bond expires. And we will also see that usually the bond is called at two stages, two likely phases. The first is that the contractor is so bad that it is really at the beginning of the project that you already given up hope that this contractor will finish the job you call. Or it's towards the end of the project where more or less it's completed. This is like your last chance saloon. You don't really need the contractor anymore. If you pack up and go, it's okay. I can get somebody to finish the balance job. But if I don't call now, then the right is lost forever. So usually we see that the bond will be called in these two phases. During the other time when you still hope that the contractor will continue to do the work, it's unlikely that you will want to invoke this nuclear option, to declare war, you see. So particularly in this kind of scenario, especially in the second type where I say the work is close to completion, that is when a lot of the abuse will happen. Because my view is that when at the beginning of the project or at the earlier phase of the project, if you know that this contractor is not going to work, and you know that, look, the only way to go is split, to go down, and of course, you need more money to finish up the work and things like that, I can see a good justification of why you need that sum of money so that, you can bring your project to a completion. But not so much the second type where, ultimately, the bond is to secure the performance of the contractor. And the big part of the performance of the contractor is split into two. One, the performance is to do the work, to finish the project for you. And if you're close to completion, actually that part of the obligation is more or less done. Now, the second performance of the contractor where, you may justify the call of the bond is, hey, because of the delay, he needs to pay me a lot of money. So, but that has got nothing to do with the completion of the work, you see. So that is the part where I think it's sort of like, it's open to abuse in the sense that actually the delay already happened 6 months ago, but because you still need the contractor, so you keep the bond warm, you don't want to call. Only when you make him continue to pour all the resources in, and finish up the job. Here you go, you want money? I'm sorry, I'm going to pull your bond, and so and that is when I think the over securitization issue will come up, and all these things. So we can see that a lot of the situation where the injunction against bond is granted actually happened towards the end of the project. You see, so I think, is there a good time to call for the bond from an employer's perspective? I would say that yes. If you want to, if there's something genuine, it should be the earlier phase of the project, and as a general rule. When you come to towards the tail end of the project, I see the case of calling the bond, especially calling the full sum of the bond, as being weak, and is open to attack on the ground that this tactical move, this is just a chance that you want. We call it sapu money first, that kind of situation. And I think the possibility of an injunction being granted on the count of such conduct, will also increase.
So this is interesting. So Hon Ling has mentioned that in not so many words, he can foresee two stages in which a call would be made. Now, Vishal, we started with you in terms of calling on the bond from the employer's perspective. Now, Hon Ling already has an idea as to when that call is going to be coming. How would you counter, or how would you strategize in light of this information? How would you prepare your clients, or how would you prepare the employer? What are the steps? I know Adrian mentioned you have to look at the underlying contract. So everybody is looking at the underlying contract. Are there anything else that you'll be looking at, strategizing so that when you pull the trigger, the money comes straight to you, what are the things that normally goes through your mind when advising the employer?
Is Vishal?
One very useful thing an employer can do, even if the contract does not. Pardon me?
Sorry, you are breaking out a bit.
Oh, pardon me. Can you hear me now?
Yes.
One thing I usually advise employers to do, even the contract does not cater for it, is to be transparent with the contractor and to notify the contractor of this intention, regardless of whether the contract provides for it or not. So that is something that an employer can do, and something that the courts will recognition of. So acting transparently with the contractor, regardless of whether the contract specifically requires you to notify the contractor or not.
Is that something that you share, Adrian? Assuming that you are advising the employer.
Well, I will say I see Hon Ling's point in terms of the two scenarios where call is likely made. I mean, in the case of a termination, you will have the issue of the cost overruns and all that, and you have to do a tabulation, and that's when you usually pull the trigger on the bond. In the case of a project encountering delays, I will say I can see where Hon Ling is coming from. If you're acting for the contractor, but if you are to wear the hat of the employer, just to make it interesting, I think it really depends, because if the project is in severe delay, of course, there will be issues of EOTs being at play about who is at fault for the delay. But when the project is in severe delay, on the face of it, take the issue of EOT aside, assuming it's prima facie kosher, then you will have LADs being clocking up, raking up LADs up to a limit. And from the employer's perspective, whilst the contract provides for it, the prospect of recoupment is something that is quite real, because especially towards the tail end of the project, the fear is that a contractor will just pack up and run away. And we've seen these cases happening. Now, usually in the case of delay, the likelihood is that the bond will have come close to expiry as well, because when the contractor initially provides for its bond, it's based on the original contract period. So there's the issue about whether a contractor will even renew its bond. Most contracts have the obligation to renew. And in reality, we've seen that this is going back to the issue of whether you call on the bond or not. It's not as clear cut as that, because it's usually a tug and pull between the employer and the contractor during this extended period. And underlying contracts have the provision sometimes where if the contractor doesn't renew the bond, then the employer can call on the bond and convert it into a retention-like fund. So again, if the contract provides for it, the employer has the remedy to it, I think there's nothing wrong, because both parties agreed to it. Whether or not the employer's actions is proper really depends on the rights that he has under contract. But I would just say that I hear Hon Ling mention earlier that performance bond is really for performance, but in terms of the wordings of the bond as it is today, it's quite widely worded. For any breaches under the contract, the employer can call on the bond. Now, of course, the second part is the more difficult part. How much do you call? You can call in part, or you can call on the whole sum. So my advice to employers will really, you need to crystallize and have a proper account of how much you have raked up in excess, after deducting the excess that you have already in hand, all the other securities. Does it justify the call on the bond, either in whole or in part? So that's, I mean, if you want me to wear the employer's hat, probably that's something I will be looking at in terms of the advice given to employer.
But as I understand it, if it's a on-demand bond, why would an employer be needing to venture into that aspect? I can just call in the bond and we'll figure everything out later.
Well, I think it goes back into this realm of unconscionability. Do you really need to call on the whole part of the bond? For example, if you have retention funds available to you, and you are, yes, no doubt the contract is in delay, but whatever funds that you have, whatever security you have, whatever payments you have withheld on account of LAD has already been catered for, then what justification will you have when you're dealing with an injunction? Because you prepare for that. If you're an employer calling on a bond, you need to be prepared that the bond will be restrained. And when it's restrained, you need to be prepared to deal with it. And that's when the issue of unconscionability comes in. Because if you don't have the right, or it's not, if you don't have an access which can show why you are calling on the bond, then even if there's a breach, then what's the loss to you as an employer? So I think that's touching a little bit into what Hon Ling has mentioned earlier, that it's not fair if you have gotten me to finish the job, and just because of I'm in a slight delay or whatever, you call on the bond. It's not fair. And that's when usually injunctions are given.
Okay, so we've spoken about unconscionability quite a fair bit, but we have not contextualized why we're talking about unconscionability. And I want to try and bring Hon Ling into the picture again. So what should a contractor do when a beneficiary, for example, an employer, calls on the bond? Is there a way to prevent a call? What are the strategies to deal with an impending or a call on the performance bond? I think we'll venture into the discussions of injunctions. So maybe Hon Ling, would you like to take on this set of questions?
Well, I guess there's no way to prevent the call of the bond because that trigger is always with the employer. And I mean, much as I admire Vishal's frankness to have good communication with the contractor, but you always act in stealth. If you can, you slip the demand letter underneath the door, and run away. And so the expectation is that this will be they will act in stealth. And therefore, there's really no way in that sense to prevent from calling. The only thing that can be done is that you put yourself in a position that you give you a better chance of restraining a call. That is the only thing that you can do actually. So I think we are in an age where it looks like the ability to get the injunction or the ground to get the injunction have loosened up a little bit, especially after the Sumatec case. And in fact, because of that, I do feel that the discussion on whether it's conditional or unconditional somewhat has become academic, because whether it's conditional or unconditional, it is still subject to this test of unconscionability. So in that sense, it's not like if mine is an on-demand bond, then even though I'm unconscionable, no matter how wrong I am, the court cannot injunct me. That's not the case. So therefore, I think that attention on whether it's conditional or unconditional, or the effect of it being unconditional, probably has been in a way diluted in light of the development of unconscionability as being a principle accepted to restrain a bond. So I think from the contractor's perspective, the situation is always that yes, there is a way to prove unconscionability. The category is not closed. The most likely situation that the contractor will rely on is that you do not need the money, employer, okay, or you're not entitled to the money, or at least not the sum that you are demanding. Shannon is right that the bond is meant to be something that you just take the money. The employer is not required to go to court and justify why am I calling 30 million, and not 2 million, do I need to show the proof? But certainly there is a line to be drawn somewhere, it's just like, I think it just go back to the LED argument. No doubt the court have loosened the way how we look at LED, but it doesn't mean that something that is exorbitant, the court will just, disregard that, or will just still enforce the LED, because even though under the cubic electronic principle. If yours is exorbitant, the court will still step in. So I think in that sense, the court will never shirk from that responsibility in a way to prevent abuse. So I think from the contractor perspective, ultimately is to put yourself in a position that to give you a better chance of getting an injunction is to show that the conduct of the employer is unconscionable, and I would generally classify them into two categories. One is financial aspect, in the sense that you don't need so much money. Another one is tactical aspect. That means you are using the bond for a collateral motive, for a collateral purpose. For example, and I see you, the first thing you go and do, you go and pull my bond. Before this, you're completely quiet. Or we are actually negotiating some sort of a final account or whatever not, a settlement terms, and I'm not happy about it, then you're going to pull my bond. So these are the things that probably from a contractor perspective, we need to be wary of. And but like it or not, restraining a bond demand is always uphill. I don't believe any lawyer in town will tell you that it can be done, or you stand a good chance of getting an injunction. I don't think so. It's always uphill. The starting point of the court will always be that this is a bond. The bond should be honored. I'm not concerned with the substantive dispute. Then when you go for arbitration, go to court, go other forum. So I'm only looking at a very narrow window. Was the demand properly made? Unconscionability, notwithstanding that we recognize that as a principle, the standard, the threshold is still high. It's not just some disagreement over contract, for example, like Adrian say, hey, the EOT issue, you say that I'm entitled to EOT, you say that I'm entitled to LAD. Look, that is not good enough to restrain a bond. So with all these things, putting them together, I think as things stand, contractor is still in a very vulnerable position because of, number one, how the bond documents has evolved, and more importantly, how the contract documents between the employer and the contractor has become. So that, like I said, if I look at it, a bond, there are four aspects that why a bond could be called. First is due to non-completion, termination, or abandonment. I think that is a clear-cut case. So I think that there's no issue that a bond should be called in that kind of situation. In fact, number two is that non-renewal. I think like what Adrian mentioned as well. Then to me, again, that is a real loss because you're losing a security that you're supposed to have. So what else do you want me to do? Of course, I'm going to call the bond and realize that up the money and still continue to hold the money as a form of alternative security. But when it comes to LAD and back charges, that's where it becomes a little bit more arguable, because like back charges, usually these are things that unlikely to come to a very substantial sum. And more importantly, you still have your retention sum to fix the defects, and all these things. And let's not forget as well that why earlier I mentioned that when you call the bond towards the end of the project, that's when question mark will be raised, because typically in our standard contract, we do not have this progressive reduction in bond sum. So you start off the project with 100 million, or 200 million project, and because of that, you've got to give a 10 million bond. That 10 million will always remain there right at the beginning. And even until the very last day, when you renew it every 6 months, it will still be 10 million, although the balance work may only be worth 2 million. So without all these things being in place, that's where I think the contractor position is vulnerable. So which is why I think some of the things that we always have in our discussion is how to make this bond system works better, as opposed to every time you just end up in court and say that one party is being oppressed. So I think being an employee between the employer and the contractor, if it can enable things like gradual or progressive reduction in bond sum, I think that is a good step forward, especially when your project is closer to the finish line, where your risk in that sense is less. Then with all this together, then I think we probably can make this system work better. Otherwise, as things stand today, I must say that it's always difficult for the contractor. And now also with a further development, which is also quite trendy, you don't get your CPC until you get your CCC. And CCC will be out of your hands. Sometimes it can drag on for 2 years. All your work is done. You pretty much have demobbed from the site, but just because the CCC is not done, so you got to continue to renew your bond. continue to have that bomb ticking. You don't know when the trigger will be pulled. So I think all these factors, when you put together in it, is that's where it puts the contractor in a weak position. And like it or not, that is in a way, the commercial risk that contractor will take. I have no good solutions of how contractor can protect themselves against the calling of the bond, because to me, there's none. I think both Vishal and Adrian are right that if the employer did do it properly, okay, then it's rather hard, to overcome that. I mean, did it properly in the sense that how they strategize the demand, how they make the demand, and how they pitch themselves in terms of justifying the demand.
Okay, so maybe let's take this one step further, and I'll open this question to the panelists. Is there a way to call on the bond, but only partial call on the bond? Or do I call on the bond, and can the court then say, look here, when I look at it, I can only release part of it. How does that work? Maybe, or there's no such thing. It's all or nothing, or it must be provided by the bond itself, the structure of calling partial. Can someone maybe explain this concept of partial call?
It has to be provided by the bank guarantee.
I see.
The bank
So it's not a
guarantee will
mechanism. It's not a mechanism where you call and then they can decide to award half. That's not how it works.
So what the court will do is the court will look at the actual demand that has been made, and they will assess the conduct based on said demand and determine whether that is unconscionable or not. The court will not modify the conduct, but will apply unconscionable, because it's unconscionable conduct. So the conduct of the employer is what is going to be assessed by the court.
Understand.
I would think that the bond usually, I mean, they will always say that this is to guarantee the sum up to, certain sum. So it's not a lump sum, take all or leave all. So it's always up to a certain sum. And I think most bonds allow you to have multiple demands until the fund is exhausted. So I think if your damage is 10 million, but the bond sum is 50, you call 50, then of course, the employer will be opening themselves up for what you call that, a wider attack in terms of unconscionability. While it's right that the employer does not need to justify that I call 10,500,000 ringgit and exactly why, you probably do not. But certainly if there is a great disparity between the two that cannot be explained, then certainly the case of unconscionability will be easier to make up.
Okay, now we've spoken quite a fair bit about injunctions and the test. Could I invite maybe Adrian to take us through some of the usual processes that you see when applying for injunction? Because there's ex parte, inter partes, how long would it take? Just run us through the process of applying for an injunction.
All right, I think when we talk about the application to restrain a call on the bond or restrain the release of the sum, this is usually a step definitely to be considered by the contractor. Now, when should a contractor be alive to it? They should be alive to it when there are telltale signs that the bond is about to be called, or the employer is extremely dissatisfied, or when they are receiving letters of set off, back notification of back charges, imposition of LADs, all sorts of letters to crystallize the debt owing to the employer or assert of breaches on the part of contractor. So that's when they usually come alive with it. And if they seek prompt advice, then usually that's when you start preparing for a possibility of restraining the call, either the call itself, or the more likely situation is after a call has been made, you restrain the receipt of the proceeds. The timeline is very tight, because once the bank receives the notification of the call, and this letter, like what Hon Ling has touched on earlier, it will usually be in stealth mode. You won't the contractor won't be notified if the contract doesn't call for it to be notified on them. But usually we know that because the bond is procured by the contractor, by its banker, sometimes they catch wind of it, that the bond is being called. And that's when they have limited time to get an injunction in place. And that is when an ex parte injunction is procured. Ex parte meaning the contractor file an application, goes to court on an urgent basis, try to get an urgent date to stop the bank or stop the contracting party from receiving the sums. So the wording of the order depends on the parties you bring into the suit. Depending on the situation, sometimes different strategies may be employed, but generally your recourse is against the contracting party, which is the employer in the case. And if you choose to bring in the bank, perhaps that's for strategic reasons or perhaps for timing reasons to try and stop everything in place. Because once the money has gone across, then we're talking about a whole different process altogether. So really, you have, I would say, less than 3 to 5 days to put together the papers. I would say 3 days, 2 days, 3 days is too many days, in fact. So you really need, it's an urgent situation. A contractor needs to furnish all its information to its lawyers, get its lawyers on board, have the papers filed on an urgent basis to get the ex parte order. Once the ex parte order is obtained, then the fight is prolonged a little bit to the inter parte process where the employer will have its say to try and argue why the injunction shouldn't be in place permanently, so to speak, pending the dispute resolution between parties. So I think in a nutshell, that's the process that we're looking at, but the critical one is the ex parte injunction order. If you can't get the ex parte injunction order and the monies goes across, then it's too sad, too bad for the contractor, unfortunately.
Okay, so what if the money goes to the employer by the time you reach to courts? Would it be useful then to insert a prayer for the employer to refund the monies? Is that something that's common practice at the moment in Malaysia?
Well, I think maybe I'll chip in first. I think I've seen this kind of prayers, but when we talk about injunctions, when you seek to restrain, when you seek to stop the employer from receiving the monies, that's a prohibitive order. But once the money reaches them and you want them to put it back, that's quite a different kind of injunction that you're talking about. It's a mareva. And the test is I think quite different, and at least that's my take on it. I have seen those kind of orders being sought for, but my take is it's a totally different complexion altogether once the monies goes across.
Okay, so what I'm hearing is the threshold is high. Unconscionability is still a very high threshold to achieve. The timelines are short, and presumably to get lawyers to get the papers ready to run to courts is going to be quite expensive affair. Then is there any reason then to fight a call? Maybe Hon Ling?
Well, I think in a way you have to, not that you have a choice, because you don't fight the call, the money will be gone, and whatever security that you have with the bank will likely to be realized. And sometimes this can trigger other defaults and other issues, may put your other projects at risk or financing for other projects at risk. So it does have a very severe consequences, in that sense. So that's why we have seen actually nowadays there are a lot of injunction cases that goes to court. Of course, people will also query then, with all the injunction cases, does it mean that the effectiveness or efficacy of a performance bond is reduced. When the employer make the demand, they expect to have the money in 5 days. It ends up that they are not having it. So in a way, it doesn't really affect the employer's right to receive the money per se, because once the demand is made, it's made. So the money is with the bank, it's safe. So at the end of the day, if the injunction application is allowed, then also you should not get the money because that was unconscionable. But if the injunction is dismissed, then you will still get the money. The bank won't run away, in that sense. So you may get a delayed receipt of money in that sense, So that is why I think that is also part of the reason why many cases you try injunction, at the High Court you fail, you appeal, and then you go and get a stay. You say that it will become Newgate 3, the money is safe, there's no prejudice to the employer. And the employer, is a bit hard for the employer to come out and say that, hey, look, I need this money in order to pay my staff. I'm going down, because more so that then, you should not be getting hold of the money if you're in that kind of situation. So no employer is going to make that kind of admission. So then it drag on, sometimes it drag on for 2 years, 3 years before you receive the money, So I think but that is just what you call that, the inherent nature of legal process, the due process. But the only comfort that I can give to the employer is that at least once you make the demand, the money is there, it's locked. The bank cannot release the security to the contractor so long as the demand is still there, it's not withdrawn, and no court has ordered an injunction. So it's just a matter of time before that will be dealt with, So that's why I think even for contractor, sometimes it's just to delay. Sometimes it's delaying the inevitable, I must say. But they have no choice, because sometimes the bond sum can be quite large, and can be difference between the company surviving and folding. And yes, this money, maybe at the end of the day, you can go through an arbitration, go through the final accounting and get it back to show that actually the employer did not suffer this loss, I should get my money back. But we know that process is going to be long, and the actual recovery is also uncertain.
I think we've really covered in detail some of the problems affecting performance bond, some of the issues employers face, contractors face, and the strategies employed. So it's a very, very detailed discussion on a short period of time. Now I want to try and take a step back. Is there a better way? Let's go back in time when we are negotiating the terms of the performance bond between parties. Is there a way to make the bond regime work better? And I remember Hon Ling mentioning this. Is there a way to make the bond regime work better by striking a balance between employer and contractors' needs? Maybe to lead the discussion, and we'll start off with Hon Ling, and then let's go down to Adrian and Michelle.
Well, certainly that there is, in the sense that, like I said, the problem with the bond now, a lot of times when contractor runs to court, is because, like I said, I'm talking about the bona fide cases. I'm not talking about those that you are guilty as charged. But you just want to delay the inevitable. You're just wasting everybody's time. And go and try to delay the inevitable. I'm not talking about those kind of situations, but I'm talking about situations where the bond may be, in that sense, be open to abuse, and that is where I think there are various ways that from an employer's perspective, is that you also want certainty on the bond. You want to make this bond, in that sense, as injunction-proof as possible as well. So one way I think of looking at it is that if the bond terms are being prepared in a fairer manner, that will give quite a different flavor, to the entire case. Because I think more often than not, the employer will be seen like a big bully. Okay, yeah, you're holding me 30 million payment. Yeah, I have uncertified work of 50 million, and yet you still want to take my last 50 million in my bank. So, and that sometimes can be true, but this will be the picture that a lot of contractors paint the employer. So I think if we look back and say that, look, how do we make this bond fairer? So I would suggest a few things. So number one is that we need to pay a bit more attention in terms of the period of the bond.
Mm.
So the period of the bond must commensurate in the sense with the role played by the contractor for the project. Number two, of course, is the amount. I know that standard we put 5%, but let's not forget, right at the beginning, the employer can take 5% as the secured sum if the contractor already finished 70% of the work. Why do you still need the same 5%?
Mm.
When whatever needs to be finished by other people is only the 30%. So there is certain a mismatch in terms of proportionality of the kind of security that you want at different stages of the project. And if that can be addressed, then certainly I think that will make things easier in the sense that will make the bond looks fairer on paper. Okay, and because ultimately these things about unconscionability, you can't run away from the word fairness and reasonableness. And what is fair, what is reasonable? Sure, somebody can take a very strict contractual situation and say, you sign on the dotted line, too bad, tough luck, that's what it is. But certainly, I think we've seen enough that in some instances, the court will interpret certain clauses in a different way because there is a perceived unfairness, whether in terms of how the contract was entered into, the terms of the contract, and how the contract mechanism works. So having that fairer contract, especially contract that governs the bond, then I think that will go a long way to readdress this balance so that the employer, no doubt, you may end up having a smaller bond, but it's a more certain bond, let's put it this way. And you do not need to trouble yourself and say, let's count how much losses that I suffer, how much LED I need to pay to the purchaser before I call on the bond, and things like that. So I think period of the bond is one thing, a progress reduction of the bond sum, because you're supposed to renew it every 6 months or 12 months, then you have a review window there, that how much is the balance work, and all these things, and then you work out a way to determine how much is the bond sum to be renewed at the time. The option to retain money in lieu, I think that's another way of also elevating some of the issue with non-renewal of bonds. And then I think the issue of whether or not there should be a prohibition of calling the demand of the bond after completion of the contractor's work, especially. I think that is also something that is playing in my mind. That because, like I said, that is one area where it is often open to abuse. So I think the bond will also need to be taken into account together with all other form of security, including retention sum. So in a way, if we look at it right at the beginning of the project, you only have 5% performance bond, you have 0 retention sum. At the end of the project, when your exposure is much smaller, other than LED, which is a separate issue, you have 5% performance bond plus 5% retention sum. And plenty of withheld payment, uncertified payment, and everything else. So again, there is the disproportionality, and that's where the pressure builds up, because along the way, I'm sure there will be some payment dispute that I don't get paid enough. And then I'm looking at this big, huge exposure of bond. And then there's a sum retained, the retention sum is there, it's up there. So that's why the calling of the bond will feel even more painful. And in which case, of course, the contractor will be forced to act.
Adrian, anything to add?
Well, I think in terms of the law as it stands, it's already quite a fair mechanism to look at balancing the interests of both parties. Because at the end of the day, I think the common theme from where we all our views are is that both the employer and the contractor must act in good faith. So in terms of the employer, if you're calling on the bond, there must be genuine reasons and not to punish the contractor or not to grab hold of the money to bully the contractor. On the part of the contractor, of course, if there is a need to renew the bond, then they have to renew it according to the terms of their bargain. In terms of where Hon Ling's idea of reducing the bond gradually, I agree that's something that could make it, from the contracting party's perspective, to look into these issues in a better, with more good faith, so to speak, because then both parties are assured that the bond is there not to punish, but as a form of genuine security. There is a gradual step down, but of course, when that mechanism is put in place, proper administration is important, and also the contractor then has the onus of ensuring that the bond gets renewed with its bank promptly and with the new figures in place, because this frees up its collateral that was put to procure the bond as well. So there's incentive there for the contractor. There's good faith there on the employer. So perhaps when the time comes for a call to be made, and a call is made, it's easier for the employer to justify and say its conduct during the course of the contract has been above board. So that could perhaps help. And I think the rest of it, the court will assess the situation on a case-by-case basis. So the mechanisms are in place. And I think that's about all I have.
Vishal, anything to add to the conversation?
I couldn't agree more with Hon Leng's suggestion, and it's agreed by Adrian, to tie the amount of the bond with the progress of the works. Of course, you'd have milestones, and in any event, you'd have to renew the bank guarantee. So, and I've noticed some contractors have proposed this, but more often than not, the employer would say no. The employer wants the retention, the employer wants the 5 or 10% bank guarantee sum. So it's a good idea, but whether it's something that can be implemented, I think it's going to be a bit tough.
Unless, of course, you have a project that requires testing and commissioning right at the end.
Sure.
And the failure to get that testing and commissioning means that 80% of your work is useless. So then probably the structured tier may not work. Okay.
Well, just to throw it in, I think that depends on whether it's a design and build or build only. Because if it's design and build, then usually there will be a design guarantee bond tied into that. So that's another layer of bond that is, or another layer of security that's tied in. So, well, it really depends on the nature of the project itself and how much security is enough. Because we are now talking about projects that are worth more and more money. And the bond, even by percentage, is higher and higher. So cash flow is choked in a way.
Perfect.
I think one problem with having this milestone progress versus amount is the employer would usually turn around and say, my retention sums are to cover my defect period, but at the same time, my LED is raking up. So I also need the bank guarantee money to make sure I can cover all angles.
Okay, perfect timing. I'm going to open the open questions from the floor. I do see a question being posted. Can you suggest prayers to be included in the injunction application?
Well, I think the standard prayer will certainly be number one, against the employer, don't get the money, don't touch the money. Yes, sometimes we have a throw in to say that if you have received the money, then you need to park the money in a trust account somewhere pending the disposal of the injunction. How effective is that? I don't know, but because most of the time you must get that order out before the money is released, or else most likely you'll be too late. Then, of course, most of the time we also put bank as a party to say, hey, look, you should stop payment pending the disposal, or whatever. Although most of the time the bank is just a nominee defendant, unless there can be some situation where we see the demand, we think the demand is wrong. Maybe they decide the wrong ground, or they put the wrong details or whatever, it's inherently defective, but yet the bank wants to honor it, then maybe you have then a separate, in that sense, grievance against the bank. Otherwise, the bank is just a passenger.
Thank you, Hon Ling. Could I open the questions to the floor? Anyone who would like to ask a question? Now is the time, because we have exactly 1 minute before we end. I think there's none. You guys have done a fantastic job. There's no question.
From what Hon Ling just said, can I just add?
Sure.
If you look at most grounds of judgment, the court would usually reproduce the terms of the injunction order.
I
So
see.
that's a good starting place to get clues on what is it that you should insert into your prayers or your order.
And I think you can do a search on the e-filing list and
Oh, yeah.
fish out the course papers these days. Over to you, Sharifah.
Thank you, panelists, and thank you everyone for joining us this evening. I hope that everyone has taken a thing or two from this session. Before we close, I'd like to highlight that we will have 3 more big talks before we end the year. Upcoming one will be on expert determination and early neutral intervention. And the second one will be our dispute adjudication boards in managing claims and disputes just hype or effective. And last but not least, Section 25 of SIPA 2012, how to interpret and implement in practice. Now, if you'd like to check out our previous Big Talks, we will be uploading it onto our website. If you'd like to follow up on your CPD points, you can also follow up with your respective bars. And thank you so much, everyone. We'll see you next time.
Thank you.
Thank you.
Thank you.